Today, the use of independent contractors is widespread, and that's because independent contractors provide flexibility, expertise, and cost savings. The use of independent contractors have come under heavy attack in recent years, and that's by the government, such as the IRS and the Department of Labor, as well as by private lawsuits, including class actions. And as a result of some of these lawsuits, many businesses have actually gone out of business as a result of their use of independent contractors where it's found to be unlawful. The government's beef with businesses using independent contractors falls into a few categories. One is lost tax revenue. There's a better chance for the IRS and state taxing authorities to collect taxes if they're being withheld by employers from employee paychecks, as opposed to leaving it to independent contractors to report and pay taxes themselves. There's nothing unlawful about using independent contractors. The problem is when the government or when individual litigants claim that workers have been misclassified as independent contractors, that they're really employees for purposes of tax laws or employment laws. It is important for the businesses that use independent contractors to evaluate their use to make sure that they are complying with the various employment and tax laws that regulate the employment relationship. The problem for businesses is there is no one independent contractor test. In fact, there are many federal tests, there are many state tests, and here in Massachusetts, the test contained in the Massachusetts Wage Act is particularly onerous. What we do for clients is evaluate how they use independent contractors, and we evaluate it under the various statutes that apply. And sometimes the advice to the client is that they must reclassify those workers as employees. But many times we find that by making some small changes to the way they utilize independent contractors, we can greatly reduce their legal liability. Employers faced with lawsuits by individuals who have been treated as independent contractors but now turn around and claim that they were misclassified, the exposure for employers is substantial damages, which can be monies that were deducted from their pay because they were not treated as employees. Sometimes it's overtime pay, money they would have received when they worked more than 40 hours a week. In addition, under the various statutes that apply to the employment relationship, particularly wage and hour laws, there are often multiple damages that can be recovered by the employees. In Massachusetts, triple damages arising out of the misclassification of workers as independent contractors. What some of our clients face is the fact that they are using independent contractors, but everyone in the industry is using independent contractors. And so for those clients to then convert those workers to employees would put them at a competitive disadvantage. Many times when we evaluate the situation, we see that the employers can make some small changes in the way that they use the independent contractors that will allow them to continue using them, but also reduce their legal exposure significantly.